You've just been in a car accident in Florida. You feel okay, and you figure you can deal with any soreness later. But knowing exactly when and where to get medical treatment could mean the difference between getting your bills covered and paying thousands out of pocket. Because in Florida, wait too long and you could lose your personal injury protection benefit entirely and hand the insurance company a reason to fight your claim from day one. Hi, I'm Pablo Tamayo. I've been practicing law in the state of Florida for almost 2 decades. And the question I get asked more than any other after a car accident is this: should I have gone to the doctor? And listen, I understand the hesitation. Maybe you're feeling okay right after the crash. Maybe you're worried about the cost of medical treatment. Maybe you think you're being overly dramatic. But let me tell you something, as someone who's handled thousands of car accident cases in Florida, the timing of your medical treatment can make or break your entire case. The 14-day rule every Florida driver must know. Here in Florida, we have what's called personal injury protection law, or PIP coverage. Under Florida Statute 627.736, you have exactly 14 days from the date of your accident to seek initial medical treatment. Miss that deadline and you could lose up to $10,000 in immediate medical benefits that you've already paid for through your insurance premiums. But here's what most people don't realize. This isn't just about getting your medical bills covered. That 14-day window creates a legal presumption about the severity of your injuries. Meaning, insurance companies love to argue that if you didn't seek treatment within those first 2 weeks, your injuries must not be that serious. They'll use this against you later when you're trying to recover compensation for your pain and suffering. I had a client last year, let's call her Maria, who was rear-ended on I-95. She felt a little sore the day after, but she was fine. Day 3, day 7, day 10 went on. Finally, 2 weeks later, she woke up with severe neck and pain and couldn't even turn her head. When she finally went to the doctor, the insurance company's first response was, well, if she was really hurt, why did she wait over 2 weeks? That delayed treatment cost her thousands in the settlement. She still had real injuries. They may not have been life-threatening or catastrophic, thankfully, but she was still very much injured and dealing with pain. Your body is designed to protect you in traumatic situations, and that protection comes in the form of adrenaline and endorphins. These natural chemicals can mask serious injuries for hours. Soft tissue, herniated discs, these don't always announce themselves with immediate obvious symptoms. I've seen clients who walk away from accidents thinking they were perfectly fine, only to develop debilitating headaches, chronic back pain, or cognitive issues weeks later. The problem is, the longer you wait to establish that connection between the accident and your symptoms, the harder it becomes to prove it in court. Not every accident requires an ambulance ride to the emergency room, but you need to be strategic about where you go for treatment. If you're experiencing head trauma, loss of consciousness, severe pain, or numbness, an emergency room is your only option. Don't second guess yourself on this. For more moderate symptoms, neck stiffness, back soreness, mild headaches, urgent care can be appropriate, or a chiropractor, especially if your regular doctor can't see you within the critical 14-day window. What matters most is creating that initial medical record that documents your complaints and examination findings close to the accident date. Your primary care physician is often the best choice if they can accommodate you quickly. They know your medical history, they can provide continuity of care, and their documentation tends to be more thorough than urgent care visits. Plus, insurance companies are less likely to question treatment from your established healthcare provider. When you do seek treatment, be completely honest about your symptoms, but be careful about your language. Don't minimize your pain or discomfort. If your neck hurts, don't say it's just a little sore. Describe exactly what you're feeling: sharp pain, dull ache, stiffness, shooting pain down your arm, whatever the case may actually be. But also, obviously, don't exaggerate. Medical professionals are trained to spot inconsistencies, and any suggestion that you're not being truthful will follow you throughout your case. Stick to the facts about what you're experiencing. Every medical visit creates a record, and that record becomes evidence in your case. Make sure your healthcare providers document not just your physical symptoms, but how those symptoms are affecting your daily life. Can you sleep throughout the night? Are you having trouble concentrating at work? Is it painful to pick up your children? This functional impact documentation becomes crucial when calculating damages for pain and suffering. Under Florida law, you're entitled to compensation not just for your medical bills, but for how your injuries have affected your quality of life. We need that medical record to help tell your story. I oftentimes tell my clients to keep their own journal as well. Write down your pain levels each day, what activities you couldn't do, how you slept. This personal documentation often fills gaps in that medical records miss. Getting that initial medical treatment within 14 days is just the beginning. If your doctor recommends physical therapy, specialist consultation, or imaging studies, follow through with those recommendations. Insurance companies love to argue that if you were really injured, you would have followed your doctor's orders completely. I've seen cases where clients feel better after a few physical therapy sessions and stop going, even though their therapist recommended continuing care. Well, months later, when their symptoms returned or re-aggravated, the insurance company argued that the gap in treatment proved the injuries weren't that serious. Florida's comparative negligence law means that any failure to mitigate your damages, including not following medical advice, can reduce your compensation. Don't give them that ammunition. The insurance company investigation timeline. While you're dealing with your medical treatment, the insurance companies are conducting their own investigation. They're pulling your medical records, interviewing witnesses, and analyzing the accident scene. The sooner you establish that medical connection between the accident and your injuries, the stronger your position becomes in these negotiations. Insurance adjusters are trained to look for gaps, inconsistencies, and delays they can use to minimize your claim. Prompt, consistent medical treatment is your best defense against these tactics. Now that you understand the importance of timely medical treatment, you're going to face another crucial decision that could cost you thousands if you get it wrong. The insurance company is going to call you with their first settlement offer, and they're going to make it sound like a generous one-time opportunity that you need to accept immediately. That first offer is almost never fair, and accepting it could be the biggest financial mistake of your life. In my next video, Should I Accept an Insurance Company's First Offer?, I'm going to break down exactly how these initial offers are calculated, why they're typically so low, and the specific strategies insurance companies use to pressure accident victims into settling too quickly. This information could literally be worth tens of thousands of dollars to you. So make sure you watch that video before you make any decisions about settlement offers. Your future financial security might depend on understanding what I'm going to share with you next. So I'll see you over there.